Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things, you've Father, you done for me, yeah. Words are not enough to say thank you. Say, Lord, you are, you're my everything. Say, I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything. Uyamatingina. 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 Oh, uyamatingina. Yeah. So, uyamatingina. I call you Jireh, say. I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are my everything.
Lovely people, we are live on BWTV and we bring you the community and the law. Today we're looking at the topic: has your child been refused UK visa? There's still hope for your child to join you in the UK. That's what we're going to look at, and that reassurance will be further explained as our guest and resource person, Lawyer Charles Asma, will be taking us into that. The community and the law bringing you updates and all the rest of it when it comes to the law, brought to you by BWF Solicitors.
Hello. Yeah, you're good. Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422-780. It's the community and the law. My name is Oreku Frimpong, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
It's another wonderful Saturday afternoon here with us in London and on BWTV, where we bring you the community and the law. My name is Oreku Frimpong, and I am doing this courtesy BWF Solicitors, our trusted partners when it comes to the law. BWF Solicitors helps us with all our immigration matters and other legal issues. And when it is that you're putting in any application, you need to trust BWF Solicitors to do this for you. BWF Solicitors are on the 4th floor of the other house, 214 to 218 Tottenham High Road, Seven Sisters, North London. You can call them on 0208 493 7340, 0208 493 7340. Or if you have any emergency situation, you can call 077 127 61884, 077 127 61884. BWF Solicitors are trusted partners when it comes to the law.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884. Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884. Award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you for sticking around. Community and the Law is brought to you by BWF Solicitors, as I mentioned earlier on. This afternoon, I have with me a friend, a brother, a teacher, a strategist. Last week, those of you who were on the program, he took us through the strategies as to what we need to look at to adjust ourselves to the situation. This afternoon, he's going to help us look at another topic. Your child has been refused a visa to the UK. He is telling us, or BWF Solicitors, I should say, is telling us that there's still hope for your child to join you in the UK. We're a bit back in time, we're a bit late, but we'll definitely quickly run through the program and you don't miss anything. So stick and stay, and let's get into it together. But first of all, let me welcome Lawyer Charles Asma to the program. Charles, good afternoon.
Good afternoon.
And thank you for coming on the show again. We appreciate your time this afternoon.
Pleasure.
Great. I will start off with the appreciation that we normally get. The nuggets that we put out helps people. And apart from that, we also have people giving us feedback on social media platforms and on Google as well. Also, this week said to us that BWF Solicitors are the best. My encounter with them was extraordinary. They did a brilliant job for me and my partner. They went the extra mile to help us, especially my partner, by requesting waiver for life in the UK test on medical grounds. I would say kudos to BWF Solicitors. I would therefore recommend them to everyone that is looking for their service. This one is a bit unique. Unique in the sense that we know fee waiver is for Home Office application fees, but this one is talking about life in the UK test waiver. Do you do that, or is that allowed?
Right. So there is waiver for money and waiver for conscience. I will explain the two. Waiver for money is what we call fee waiver. Waiver for conscience, such as this one, is the medical waiver.
Okay.
So medical waiver is where the person may not meet certain requirements within the rules for the application. And so on medical grounds, they have to waive the test or the requirement for this person. So our client in this instance was applying for naturalization or indefinite leave to remain, for example. I think it was a naturalization. And the rule is that you must pass life in the UK test and also English language B1. Unfortunately, not everybody is able to. And the rules say that if you're not able to pass the test for life in the UK and English language, you have to show that there is a reason why you cannot do that.
Okay.
And the reason should border on disability or health grounds. And disability here, we have to look at which part of the body that will be obvious that you will not be able to use that body or part to achieve the exam result. So in this case, if you are suffering in your leg, it wouldn't be an issue. If you are suffering in your arm, it wouldn't be an issue. And so the only part that may cause issue for you to pass exam is your brain. And so if you have mental health complications or issues, could be stressful episodes, depression, and what have you, that is preventing you from writing exam, then you have to let the caseworker know. In this case, you get a medical waiver form from your GP or consultant, certifying that you are not able to sit and pass exam because of the conditions they know it to be about. And because they are treating you, they know you well and they can attest to. Because it's an independent medical assessment or report, the caseworker will take it into consideration. So there's a standard form to use. And once we add it to the application, we explain that the rules say that exemptions apply for people such as this, and our client meets the exemption clause, and this is the evidence, and the caseworker should take that into consideration. If the caseworker is satisfied, then the person's application will be decided without the need for English language test and also the Life in the UK test. So our client was able to go through that assessment, provide the evidence, and the caseworker was satisfied. And this is what we do. Because when people come to us, we say, lawyer, I've been trying several times to pass the exam, but I have not been able to. What options are there? We tell them that the rules say those who cannot pass should have a reason, and the assessment should come from their doctor. So speak to your doctor and let them, or the school or the college or the center that is preparing you for the exam, let them prepare a report, what we call needs, special needs assessment report, to show why over the years you've tried, over the period you've tried, you are not able to achieve because of your learning needs. And if that is tenable, then it will go through or pass the assessment. So that is a way to get around if you are not able to pass the Life in the UK and English language test for your definite leave to remain or naturalization application.
So obviously, if you have a challenge, speak to your lawyer, and I'll ask you to speak to BWF solicitors. They will weigh your case and weigh what options there are available to you and advise you accordingly. Also, thank you very much for sharing your experience with us, and we believe that others will take the same clue and work with BWS solicitors as well. The Asylum and Immigration Tribunal may consider any relevant evidence to the substance of the refusal decision, including matter or evidence arising after the decision was made. However, the tribunal cannot consider new matters without the Secretary of State's consent. A new matter is defined as a ground of appeal that has not previously been considered by the Secretary of State in the context of the original refusal decision. This is based on Section 85 of the Nationality, Immigration and Asylum Act of 2002. Rule 14, subsection 2B, is the first tier tribunal procedure rules of 2014. I've read so many things and it might confuse you. We're talking about putting in an appeal and the other things that go into it and how you can successfully add, take away, or even put everything together. And with this, as I normally do, Lawyer Asma will help me with it. Lawyer.
Thank you. Yes, so that's the nugget for today, and our authority in this nugget is the Section 85 of the Rule of the Law 2002 Act, and also Rule 14 2B of the First Tier Tribunal Procedure Rules 2014. Now, I'm going to give a simple scenario that will lead into this so that people understand clearly why are we saying that you can go for it if you didn't have it before, and the court should consider. Now, let's assume that the caseworker is telling you that the birth certificate is not right. And because of that, this is not your child. And because of that, they have refused the child. What is the issue? The issue is that this is not your child. It's a relationship issue. So that's an example.
Okay.
For the court to determine whether this is your child or not, the court should be able to confirm that this is your child. Because that's the issue at stake. And so if at the time of going to court, I'm able to provide DNA to the court to prove that this is my child, will that resolve the issue of whether this is your child or not? Yes.
Yes.
And so even though at the time of the application, I submitted birth certificate, and on that basis, they couldn't determine that I am the parent of the child. And at the time of going to court, I provided DNA, and the court is now is able to use it to confirm that I am the parent or not. Should we deny the person of using the DNA to prove relationship while the caseworker is saying that they can't rely on the birth certificate? Right. It wouldn't be fair. And so in the wisdom of the drafters of the law, they came up with the view that if the evidence is not available before the caseworker at the time of the application and at the time of appeal, the evidence is available. The question to ask is this evidence pointing to the issue or something else?
Okay.
If the evidence is pointing to the issue, the Section 85 says that the court should consider to accept the evidence.
Okay.
Even though it wasn't before the caseworker originally. That is one instance. Now, let's take another instance where the issue is about child and parent and child relationship. Okay. And I bring marriage certificate. Is this marriage certificate necessary? It appears that marriage certificate is now introducing a new matter
into the case. Yeah.
And that's why it says that if it's about new matter, then we need permission from the caseworker.
Okay.
Because that's the other party. But if it's the original matter or issue, then the court should accept the new evidence pointing to the same issue without permission or consent from the other party. And this has been also transposed into the rules under Rule 14, Sub-Rule 2, Sub-Rule B of the First Year Tribunal Procedure Rules 2014. Simply, if you are refused a visa and you go to court and you have other evidence that makes your case stronger because they help to prove to the caseworker who refused the visa that what I'm saying is indeed true, then that evidence should be accepted by the court. So you put all together and you present it as part of your evidence. And the rules say that the court should consider. So when you are presenting, what you say is that this was not before the caseworker. And so the caseworker didn't have this for assessment. However, at this point that I'm coming to court, I have it, and it helps to resolve the matter by the court. I refer you to Section 85 and also refer you to Rule 14 and conclude that this should be considered because it helps to resolve the issue at stake.
Definitely, you should know the law and you should know the ins and outs, especially when it comes to immigration matters, to be able to decipher this and draw a conclusion out of that to help your client. And that's what BWF Solicitors does. BWF Solicitors, call them on 0208 493 7340, 0208 493 7340. Or in emergency situations, you can call them on 077 127 61884. 077 127 61884. Those of you in Ghana, the office number in Ghana is 055 589 5959. Or if you want to reach Charles Asma himself, 07947 6360 37 07947 636037. And so the community and the law. And based on that, let me give you the scenario and see whether we can advise our friend in this. Selena applied for a visa to join her husband in the UK. Her husband has indefinitely to remain in the UK. Her application was refused because the caseworker was not satisfied that the pay slips provided by her husband to meet the financial requirements were genuine. Selena is appealing against the refusal. She wants to include in her evidence her husband's employment contract, a P60, and a letter from her employer to show that the payslips were issued by her husband's employer. However, she is not sure if the court would accept these new pieces of evidence since they were not part of the original application supporting documents. So let's advise Selina. Could they be one, the Home Office will challenge these new evidence because Selina did not submit them originally during her visa application? Could it be two, the court will reject the new evidence because the caseworker did not have the opportunity to consider them before the refusal decision? And three, could it be that the court will accept the new evidence because they are relevant to proving whether Selina met the financial requirements or not? Think about these. I'll come back to it at the tail end of the program for you to give me the answers, and then I'll run it by Lawyer Charles Asma to see which of them would be the best advice to give to Selina, who's made an application to join her husband in the UK. This husband has indefinite leave to remain in the UK. Application refused. Selina is making or putting in an appeal. It's not a community in the law, and I'm going to show you our social media platform and our handles. And when we come back, we go straight into the discussion for today. It's still the program you always want to run to and come and enjoy every Saturday afternoon. As I say, the community and the law, brought to you on BWTV and brought to you by BWF Solicitors. We'll be right back. Good afternoon, if you just joined us. The community and the law is the program we're enjoying. We're live on Facebook at BWF Solicitors and at BWTV UK. Also on YouTube at BWF Solicitors and BWTV UK. Has your child been refused a visa to the UK? There's still hope for your child to join you in the UK. How? If it's been refused, is that not the end of the story? I don't think so. Because when we go to BWF Solicitors, they'll look at our case, they look at the reasons for the refusal, and definitely there must be a way out. And that's what we're going to look at and do this afternoon with Lawyer Charles Asma from BWF Solicitors. Uncle Charles, my child, hypothetically, has been refused a visa to the UK. Can I still bring the child to the UK?
Yes, if you want.
To be fair, I want.
Well, then you should. Well, you should.
Yeah.
Right. Yeah. So, insofar as the rules are met,
Okay.
and yeah, this conversation is very relevant because a lot of parents are distressed because children cannot join them. At the same time, they cannot stop what they are doing to go back and live with their children. Meanwhile, there's nobody who can play the role that they were playing.
Okay.
And so they are torn between what do I do for my children? Should I give up on any hope or I should keep trying? We'll be showing one or two practical evidence of the conversation we are going to have,
That would be brilliant.
which will underscore the conclusion that it is still possible if you want to. Then at this point, we are going to look at the rules. We'll look at those practical evidence. Then we'll look at how should people go about this.
Okay. So then I believe people should get their pens and notepads ready, or bookmark the page, share it, and get people to join us to have that discussion, because it's going to open our eyes and tell us what to look for and how to go about it. And evidently, we go over to BWF Solicitors for a strategic solution. So, Uncle Charles, yes. Now let's go into it.
Yes. So the rules. In terms of children application, you remember the question or the topic did not say skilled worker or somebody with indefinite bringing children. It says children.
Children.
So you can be a skilled worker suffering from how to bring your child to the UK, having tried several times, or having heard people are suffering from that and you are even scared of attempting in the first place. Or you have indefinite leave to remain in the UK, you want to bring your child. Or you are a British citizen, you want to bring your child. Or even you have 2.5 years leave to remain and you want to bring your child to join you. The parameters. So we are looking at children whose parents are both living in the UK.
Okay.
Or children whose parents are both living abroad. I've said two things.
And both living in the UK.
Both living abroad.
And both living
and
abroad.
The third one parent is living abroad, and the other is living it's living in the same country where the child lives.
Okay.
So two living in the UK. If both parents are living in the UK, it doesn't. So what it means is, if both parents are living in the UK, then the question here is it okay for the child to join the parents in the UK? Yes, because there's nobody looking after the child. In this case, there's no need to show sole responsibility. That's point one.
Okay.
Both parents in the UK, no need to show sole responsibility. Excuse me. The next one is one parent in the UK, the other parent elsewhere in another country. Do you still have to show sole responsibility? No, not necessarily. You don't need to show sole responsibility because one parent is not in the same country where the child lives. What about if one parent is in the country where the child lives or the children live, then you have to show sole responsibility. What about those two parents living abroad, the other one not sponsoring the child? We have to look at the other parent. If they are both with leave to remain in the UK, then no issue. But if one doesn't have leave to remain, then we have to consider whether the one who does not have leave to remain or papers in the UK or immigration status is attempting to make an application.
Okay.
If the person has not made any attempt to make an application, but they are an overstayer, then that may go against the child in terms of saying that there's no sole responsibility. So where the child is not able to prove sole responsibility, does it mean that that is the end of the child? No. And that is where the issue is. Most parents are caught up in that web of sole responsibility, but they are not able to adequately demonstrate that they are solely responsible for everything about the child in terms of upbringing. So we are looking at paragraph 297 of Appendix FM to the immigration rules, and that is for people bringing their children to the UK as British citizens or indefinite leave to remain holders, or even 2.5 leave to remain holders. Then we also have paragraph SW 32 capital A point 1 of Appendix skilled worker. And you can see that this is for skilled workers. There's also paragraph CHI 3.2 of Appendix children. And this is for all children applications. Appendix children is very important to all children applications. The question here is, I've tried several times. Should I give up? No, you don't have to give up. So how do I get around this? We've looked at the legal angles or the legal context, what the rules say. So paragraph 297I, IE, and F will tell you that if the child is not living with both, the child is not living with somebody who is not the parent, and the child is joining the parent in the UK, then we have to check whether sole responsibility is an issue. If there's no sole responsibility, then it will be difficult for the person or the parent to bring the child to join them in the UK. So we are looking at E. You have to show sole responsibility. If you can't show sole responsibility, then it will be difficult for the child. What about F? F says that if there's no sole responsibility, but there is serious and compelling family circumstances that makes the exclusion of the child from the UK undesirable, then they have to consider the caseworker must consider to allow the application or grant the visa for the child. Now let's go to D of that same rule. D says that if one parent is dead, then the responsibility rests with the other surviving parent. But what if the other parent is not dead? Because if the parent is dead, you have to show death certificate. If the parent is alive, you can't show death certificate. So when both parents are alive, sole responsibility. If there's no sole responsibility, you go to the other one, which is serious and compelling family circumstances. Now we go to skilled workers. It will tell you that if you're applying for your child to join you in the UK, you have to meet the requirement under paragraph SW 32 capital A.1 with respect to paragraph CHI 3.2 of Appendix Children. What does Appendix Children rule say? It says that if you are joining your parent in the UK, show one. That's I. So A says that one parent is dead. B says that there's no responsibility. And C says that there's serious and compelling family circumstances. So you can see that whether it is skilled worker parent or somebody with indefinite leave to remain or somebody with British citizenship, the rules are the same. For one, it's just change of E to B and F to C. So it doesn't really matter. So how do I prove that sole responsibility is not met, but at the same time, my child should join me? We are going to go for the practical or the context, what has happened before. Then we move on to, so about me, how do I go about it? And I'm sure a commercial break will do, by which time the evidence would have been.
Yeah, definitely. So we're asking you to stick around and ensure that you are into the whole thing that we're giving you. It's a community, and the law is brought to you by BWF Solicitors. A resource person, lawyer Charles Asma, is here, and he is taking us through those steps. Now, has your child been refused visa to the UK? Can you, in any way, shape, or form, get that child to join you here in the UK as a family member? We're taking this break, and when we come back, we will look at the practicality of the whole issue. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Hello and welcome back again. Yes, we're looking at how we can practically get our child to join us in the UK when it is that the visa has been refused earlier before. Lawyer Charles Asma is here, and by courtesy of BWF solicitors, we're looking at how to get into it. There's still hope. Yes, there's still hope. And Lawyer Asma, can we see if we can kindle up the hope and get people to practically go through the process, as it were?
Right. So, producer, if we have the first resource available, please help us with that. After that, we'll look at a second one, which is similar to the first one. So, Bragoku, you help us to go through this. This
So,
is evidence.
Your application for a UK visa has been successful. This notice is not proof of permission to travel to the UK. You've been granted entry clearance to the UK as skilled worker, child health and care from 22nd of August 2025 until the 14th of March 2028. It's important to check that your details are correct on your visa before you travel. If any of your details are incorrect, contact us before you travel by going to the link below or as provided.
So, I think that the first bit, all that we want, no, it's okay. So the part about successful and it's expiring 2028.
Okay.
And now this is the evidence. What's the context and how relevant is this to the conversation? So this person called me somewhere first week of August.
Okay.
And said that, lawyer, I'm in trouble. What is it? Oh, my child has been refused again. Why? Because they've been trying it themselves. They sought advice from other lawyers and also non-lawyers, and they have been doing it themselves. 2 children. One has been refused 5 times.
What?
And the other has been refused 3 times. So 8 combined.
Wow.
So this application was going to be the 6th and the 4th for both children.
Right.
So he said, lawyer, is it going to work? I said, well, it's not about whether it will work or not. It's whether you can meet the evidence and the rules. So we've got the context. All this while, they will say that so responsibility, simply because she believes that she looks after the child alone. Simply because the other parent is nowhere to be found, but is living elsewhere. So I had to test the evidence and said that, hang on. The rules say that if both parents are abroad and they are looking after their children, you have to say you have shared responsibility. Why can't the children live with whoever is looking after the child? We have to then bring that in to say that both parents are living abroad. So in this case, the mother was living in the UK with the stepfather. And the original father is in Canada schooling. So who looks after the children? Somebody they have requested to look after the children. So let's go a carer, a third-party carer. The carer has not been doing the job well and is even feeling like, no, I can't be bothered, come for your children and all that. So this was important to her. We put in the application after we've collated all the necessary evidence, the school letters and all that, together with the ones that she has been using in the past. and we situated the reasoning or the argument to the fact that one, there's no sole responsibility. So it's not a case of CHI 3.2B, because there's no sole responsibility. And it's not also, because it's under skilled worker. So we look at skilled worker rules. So there's no sole responsibility. However, the other parent is in the UK and the father is in Canada. The child lives with the stepfather and the biological mother. And we concluded that the carer is not able to look after the child, and so therefore there is serious and compelling family circumstance. I also asked the person whether she's been able to visit the child before. She's been able to visit the children twice in about 2 years, at least something. We put all this together, made the case to the caseworker. Then they came back to say, can we have evidence of where the father lives in Canada? So that's green light. But that has never happened.
Never happened. Yeah.
So I asked her, tell the father to bring. We got the evidence, we sent it. Even though we had previously added the Canada evidence, they asked for more, so we sent it. Under evidential flexibility rules, they have to come for more. Then they came back again to say, can you confirm that your employer is willing to show that they are able to cover or maintain you and your children when they arrive in the UK? Because the rules say that there should be maintenance, adequate maintenance. So the employer got the letter for us. We sent it to the people, and on this date, that is August, that's about 1.5 weeks ago, we got a decision. So by and large, it took about maximum of 3 weeks for us to use the
So it's a matter of considering the reason for the refusal and also gathering enough evidence to demonstrate that their situation is different from what maybe their guidelines saying, do if it is X, do Y, if it is B, go on to that bit. So you would have to look at what they have in front of them, what the laws say,
of course,
and then what evidence you can produce.
Yes, because the whole thing is this: the caseworker is the marker. The caseworker is not the examiner.
Okay.
It's just a marker using the marking scheme, which is the guidance.
Yeah, the guidance they have read.
The rule we have read is what a caseworker is using to mark the application to grant the visa or to refuse the visa. If they grant, they must explain why they granted. If they refuse, they must explain why they refuse. So if they refuse, they will say, I'm not satisfied that paragraph so and so has been met because you have not demonstrated enough that you are solely responsible, blah 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 blah. And also there's no evidence that there's compelling and family circumstance for the child application to be considered under best interest rules. And so I refuse the child. So we have to then work backwards to say that if this is what they are likely to say, how do we meet
that
the marking scheme and get 100% of the answers? And that is how this is done.
So obviously you preempt the question, answer it, so that when it goes before them, it goes according to the guidelines. It goes according to what needs to be provided, and you get a good answer.
That's the job of the person making the application. If you are doing it yourself, you must understand the rules.
Okay.
If you are doing it through your lawyers will understand the rules and apply it to the situation. And that's why we say that every application is decided on its own merit. Even though the child has been refused 5 times, the 6th time it went, because we approached it differently and on the basis of the evidence provided and the argument put forward, and on the merit of this application, the child meets the rules and was granted. Now, the second one, producer, if you can share with us. Yeah, so a new one has been provided, which properly redacts the personal data.
So obviously, the live documents we're going to share would be documents that, for confidentiality's sake, we will have to redact certain names. And your application scroll up as a dependent of that on the skilled worker route has been successfully been granted permission to stay in the UK as a dependent child until 28 January 2028. We can take it off now.
No, we can't. I mean, the name is not legible, so
Yeah.
we'll give context to this one too.
Okay.
So this one, the lady said that, lawyer, this was somewhere 3rd week of July.
Mhm.
Lawyer, my home office has asked for evidence of sole responsibility, and they want it in 10 days. What do I do? So I said, do you have evidence of sole responsibility? He said, no. I said, who made the application? I did. Did you seek advice? Yes, a lawyer advised me. I said, really? And you put in. So what I asked for a copy of the application, and the context of it is that she applies saying that she's solely responsible.
Mhm.
But she couldn't meet the sole responsibility argument.
Okay.
And if you can't meet the sole responsibility argument, the child will be refused. Because they're also asking, where is the other parent of the child? And what shows that you have sole responsibility?
Okay.
And her explanation is that the father joined me in the UK as skilled worker dependent.
Okay.
And left for Ghana and has since not returned. And so when I'm applying, to me, I look after the child alone. So I apply saying that I have sole responsibility. And I said, no. The fact that he hasn't returned doesn't mean that you have sole responsibility.
Mhm.
The fact that you are applying for your child to remain in the UK, you have to show both parents have visa to remain in the UK.
Okay.
Because this is a child that you just, I think it was, the child is about a year old and wants to apply for a skilled worker visa for the child. So we had to set it out again, this time not a new application, but response to the application that is already under consideration.
Mhm.
So what did we do? We had to take over the case and to tell them that we are now representing the applicant, and we refer to the request made through the applicant mother and respond as follows. So I took everything from her, and then we responded first to say that, one, the mother and the father both have visa to remain in the UK.
Mhm.
At the time the mother was applying for renewal, the father did not, because the rules say that the dependent may choose to renew at the same time or later.
Later.
So he chose to renew later. Again, the father is currently not in the UK. The father left to attend to his sick mom, which is the in-law of this sponsor, the mother,
Mhm.
and has since not been returned because the health of the mother has become complicated, and he needed to choose between considering the health and well-being and life of the mother or returning to the UK just to live in the UK. And he chose the better one, which is the life of the mother. So the fact that he hasn't returned doesn't mean that he didn't want to come back. And of course, he still has visa to come back to and apply. So the issue about sole responsibility that she indicated in the child's application was a matter of misinterpretation of the law, the rules, thinking that because my husband is not around, temporarily, I am solely responsible. So the word solely, she misconstrued it and interpreted it in a layman's term. And now we set it out clearly, indicating A, B, C, D up to this point. Provided all the evidence and sent it to them. Then they wrote back to say, can you provide evidence that the mother has been unwell and the father is attending to the mother? So yes, we got evidence from the doctors. We sent it to them and said, can you confirm whether he will be coming to the UK soon to continue? We got the evidence to give to them. And
would that evidence be that he still has visa to travel back?
Yeah, he still had visa was expiring on the 14th of July. So the visa was expiring 14th of July, and this process was before 14th of July. So presumably he will be able to come and apply. Obviously, you can apply from there. But as far as the context is concerned and the conversation we are having in this case is concerned, he had leave to remain or to come back to the UK to live here legitimately at the time of this application. And long story short, the child application was granted, and that is what we see.
Okay.
So the question is, your child has been refused visa to the UK. Can the child come still? Yes. Your child is living with you in the UK, has been refused, or you are struggling to Can you still go ahead? Yes.
Mhm.
There's another one where the father, so the father is married to the lady. The child's mom is skilled worker migrant. They applied for the child who had just been born to have the mother's to an skilled worker leave.
Mhm.
Meanwhile, the father doesn't have any visa, an overstayer. They put in their own application, and the child, they asked them to provide evidence that the father of the child also has leave to remain. But
Okay.
the rules say that if the father of the child doesn't have leave to remain, then the child must be refused, regardless of whether the mother has or not. So at this point, they came, lawyer, can you take over our burden and carry it for us? Of course, we took the burden upon ourselves. We responded to say that, yes, we understand the rules say X, Y, Z, but there's also discretion to be had in the best interest of a child like this.
Mhm.
Are you punishing the child because the father is an overstayer? But the father will also make an application in due course. But in this context, if there's the need for the child to travel, how does the child travel? Simply because the father is an overstayer.
Mhm.
Don't you have to consider the best interest of,
Of
the
the
child?
child.
In this instance, they came back and say it's been granted.
Well, it's a strategy thing. So definitely you need to trust BWF solicitors to help you do this. Has a child been refused a visa to the UK? There's still hope because as we are outlining, there are ways of going about it. Trust BWF solicitors to do this for you. If you just joined us, you're live with us on Facebook and YouTube at BWF solicitors and at BWTV UK. If you want to ask a question about this topic or has any other issue that you want to put before Lawyer Charles Asma, you can call on 0208 493 7345. I'll come live into the studio and on the program. And or you can send a text to 07399208468. Then you can leave your comments and questions in the comment section down below, either on Facebook or YouTube. It's still the community and the law. We're discussing if your child has been refused a UK visa and also telling you that there's hope for your child to join because we have had two scenarios, two cases that seemed almost hopeless, but BWF solicitors took it up and helped such applicants and candidates or clients to be able to overcome those. You could be the same person. So why don't you trust BWF solicitors? Visit them on the 4th floor of the other house, 214 to 218, Tottenham High Road, Seven Sisters, North London, N15 4NP. You can call them on 0208 493 7340. And if you would want to speak to Lawyer Charles Asma himself, you can call on 07947 63 60 37, 07947 63 60 37. We're taking a quick break, and when we come back, we will pick up your questions, your concerns, either on our text number, either on the phone as you call in, or in the comment section down below. It's the community and the law.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you for sticking around. Yes, I announced the phone line, so we're ready to pick up your calls and your comments and questions. The phone lines are active: 0208 493 7345, 0208 493 7345. That comes into the studio. We already have a friend on the line. Let's go to the phone lines now. Hello.
Hello.
Good.
Good evening.
Good evening. How are you?
I'm very good.
Okay. Okay. Right. Let me put you on. And it's saying,
Yes. Yeah, me I don't know where.
well, I changed it to the Ghanaian language because our dear friend wanted to speak in the Ghanaian language, so that's fine. But what about you?
Me pacho. My question is, me serious me buy and I'm dependent. Na me buy no me know the other wo and can we you mean to acquire me ban application for the passport when and the British passport. Na me pacho say me move from COS me so kotoso. It's my filing for divorce from Ghana, but me because member office no my application and maybe na me pacho me IELTS exams it's not come a me culture because it's a culture a friend of mine my advice is a me culture yes but I'm spending 2 years 6 months they carry on to me bana me kotono so no me years no so me I carry on to I don't know how true is it and answer says I'm culture me ko 10 years route it's not me bisa me person can person me culture say it's a Mr. Semi Culture and Pacho exams buying and culture. And I'm Pacho me culture so the same few waiver because say no fear me Jima Sano for me you know. Semi culture in case a 5 years route but your few waiver no many be an answer just a 10 years route and quantity few waiver.
So let me
support
okay, let me break your question down a bit. You're on the skilled worker route, and now you want to move to the family route. Okay. And moving to the family route, you want to look at what the ramifications are. You want to apply for a fee waiver. You want to go and do your IELTS and see if that will add up to your number of years you spend, and would that also translate to your young person. You filed a divorce in Ghana. It hasn't come through, so you haven't put in, but you're hoping to come to BWF to do that. Lawyer.
Okay. Yeah. Hello, viewers and listeners. For the specific reason, we will change the dialect to respond to our friend here. Madam Pacho design. Some kind of brofo what yes here. That's fine. To make me I respond brofo. And then my main kind of brofo no be so the same way now at yes here why. All right, so viewers and listeners, back to the English language. Our friend is able to hear the answer in English. Now, the question from her is this. She came as a skilled worker main applicant. She came with her husband. She was in the UK, cheated on her husband, and had a baby with another man. Now, before the baby was born, because of the infidelity, divorce came, and she and the man she entered the UK with have separated. That is the husband. So on the basis of the law, the child was granted a passport under Section 1 of the British Nationality Act 1981, which says that if one parent of the child has indefinite leave to remain, at the time the child was born, the child is British. So her child is British. She wants to now switch from skilled worker to parent. And she wants to know whether she can carry with her the years she spent as a skilled worker. And number two, whether she needs English language. And number three, whether she can apply for a fee waiver. So we are going to answer the first one. The first one, she wants to ask, can I carry the 2 years I've spent as a skilled worker onto the family life if I'm successful with the application so that I can shorten my time in the UK into indefinite? The answer is no. You are moving onto a new category of visa altogether, and you start your journey from there. Skilled worker journeys are different. And if you are still under the skilled worker, you could have then continued up to 5 years for indefinite, but you are switching to family life. The next one is, if I'm switching to family life, do I do it under 5-year route or 10-year route? And you can do under 5 or 10, depending on whether you meet the rules. If you want to do under 5-year route, you have to show English language, you have to show the finance of 29,000 a year, and of course the relationship should be made out. And if you do that, you can be considered under 5-year route, which will mean that you stay for 5 years and apply for indefinite. Can I get a fee waiver if I want under 5 years? The answer is no. Do I need a fee waiver, and does it mean I have to go under 10-year route? The answer is yes. If you need a fee waiver, you'll be put on the 10-year route. In that case, you don't even need English language, because there's no point to stress yourself to write the exam if the exam doesn't add anything to the application, which will be considered under the 10-year route. So that is the response to our friend.
Thank you very much, lawyer. You really helped me. Thank you. Thank you very much.
And thank you very much for coming on the program as well. We hope to get you again when we have another edition next week.
Okay.
Definitely. Thank you. 0208-493-7345. Whilst we wait for another person to join us, we can pick up questions and concerns on the platform. I ask you to leave them in the comment section down below, either on Facebook at BWF Solicitors and at BWTV UK. Same on YouTube. Same handle at BWF Solicitors at BWTV UK. I'm a British citizen and I have 2 baby girls. I want to bring my mom here to help me take care of my babies. How do I go about it? Grace Press is asking, lawyer.
Right. Hello, Grace. Because you want your mother to be here to work, to assist you, your mother should have a visa that allows her to live longer in the UK, more than just visiting, and also to assist you. Such application will be made under adult dependent relative, under appendix adult dependent relative. Under appendix adult dependent relative, it says that your mother should be of age, aged mother, and I'm sure she will be about 40, 50, 60, or what have you. And in addition to that, or her health should be complicated. So if as a result of her health or age, she is unable to carry out personal tasks such as eating, drinking, grooming, mobility, and all that for herself, and she needs somebody to do that for her, or she needs assistance with that, what we call carers, then you have to show that you are not getting a carer in the country where she is. You also have to show that there is a carer, but the carer is not able to live up to the expectation, and so you are not getting quality of care for her. Again, you have to show that when she comes to the UK, you will be able to look after her, provide the care she is not getting where she is, and whether there is enough means to be able to do that. In terms of how long should you prove this for, if your mom has been unwell, then there should be medical evidence, medical report over the period, say 2 years, 3 years, to show that over the long period, this has been continuous and has been affecting her health, even making it worse. And you cannot go to live in the country where she is. And there's no other family member who can replace you to look after her unless she comes here. And this is something that you need to take time to gather the evidence. You cannot just rush into it. So an appendix, adult dependent relative applications, very, very, very high threshold. And you have to take time to make sure that you gather the evidence you need to be able to meet the rules. Otherwise, you will be refused. Now, she can also come in to visit you because she has right to visit their daughter. But she's coming not to look after you or your baby. She's coming because you have given birth and she's coming to spend time with you and the grandchild. That is the reason, and she will return to her country to continue her life. In this case, she has to show that she is a genuine visitor and she will return to her country after the short visit. Otherwise, she will be refused visitor's visa. I hope the answer is clearer to your question.
Well, thank you. And if you still would want to follow up on the question, you can contact BWF Solicitors on 0208-493-7340. Now, Grace Press comes in with another bit to follow up on her question. Does my mom need to meet any financial requirements?
We've talked about two things, so I don't know which one. Is it for the visitor's visa or for the adult dependent relative visa? Please come again.
Okay, so if you can provide us with further evidence, that will be quite useful. Let's pick up another one and see what we have. Ijenim Lexo, if you have leave to remain on 10-year route, can you bring your child from Ghana to join you in the UK law?
Yes. If you have 2.5 years leave to remain and you have a child in Ghana, you can bring the child. Again, you have to show that either you have sole responsibility or there is no sole responsibility, but there's serious and compelling family circumstances in the life of the child. We'll touch base on that so that it will be clearer once we pick up those questions, so that leaving the child behind will not be good to the life of or for the life of the child. And if you are able to do that, the child will be able to join you in the UK. When you didn't tell us whether you are under 10-year route as private life, under your private life, or under your first child, in other words, your British child. I want to believe that you are granted 2.5 under your British child, which is the sibling of the child who is yet to come in. And on that basis, yes, the child should be able to. We've done it for people in your situation and they've been successful. However, you have to show that you can provide the evidence.
You can send us your questions via text or WhatsApp 07399208468, or you leave them in comment section down below. The phone lines are active. You can also call in 0208-493-7345. I've not traveled. Says visit visa refusal stated. I've not traveled before nor not been in the UK, so if I get visa, I will return. I'm 64 years. UKVI said I have limited savings, that pension and other remittances, and my sponsor in the UK is entirely sponsoring me through, though I'm personally paying some part. How can I address this at reapplication? I provided evidence of economic ties, social ties, financial, property, and family ties. I'm going to visit my granddaughter. Visit visa refusal, not enough funds, and all the other bits. But this person is saying that he's got economic ties, social ties, and financial property, and all the other bits in Ghana. Coming to visit their granddaughter, and now they say they can't do that. The person is 64 years.
So I tell people that unlike other immigration visa categories, visitors visa category leaves so much room for discretion for the caseworker. Just like somebody throwing up a party and deciding who should attend, or someone who is having a wedding and sending invitations out. You may be the best friend, but he will say, no, on this occasion, you won't come. You can't come. Not because you don't qualify, but they just don't want you to be there. And how do you say you should let me? It's the person's own thing. So visitors visa, you want to visit the UK, they are saying that, well, they think that you are not somebody that if they give you the visa, you can go back. And normally, if you are going to try again, yes, you can try again, but it's difficult for me to sit here and say that if you provide some other things, that will make a difference. It can make a difference, or it can be that somebody else will pick this, the new evidence and make similar assessment and come up with the same conclusion. Normally, when it happens like that, I tell people that if you can afford, seek judicial review, because this is a family visit visa application, and the decision to refuse your is a mother, yeah, is it mother?
Yeah.
The decision to refuse your mother means that they are denying your mother opportunity to visit you as family, and that is against Section 6 of the Human Rights Act of 1998, a decision that prevents someone from exercising a human right, and that decision should be taken to court for judicial review. So if you can afford, go for judicial review. But if you can't afford and just want to put in application again, I cannot guarantee that it will make any difference. However, you have to show that your mom will return to Ghana to continue her life. It appears that you have provided everything that she has there. And so I can't say what else she can add. In terms of the financials, if the child, just yourself, is sponsoring your mom, then only your bank statement, adequate income or fund to be able to support or look after her whilst she's in the UK should be fine, whether she has it or not. But if she is going to provide her own financial evidence, then she has to show where it came from and what does she do to be able to earn that much. So these are the things that you have to consider. You have two options. Try again, but make sure the evidence is better than before. Or go for judicial review to challenge a human rights application which borders on the human right of your mother to visit you in the UK.
Yes, keep them coming through 07399208468. As for text and WhatsApp messages, or you can call in 0208493735, or you can use the platform on social media, that's YouTube and Facebook at BWF Solicitors and at BWTV UK. Solomon is asking, I and my partner came to the UK as skilled workers, but the care firm said they are not going to renew that for us. The visa expired, and we've had to find our own certificate of sponsorship. What should we do? And if help you could offer? Well, I don't think BWF solicitors can give you any certificate of sponsorship because it's not a care organization. But I believe that your options, they could weigh and let you in on what you could do. Laura.
Right. From the information provided, says the visa expired. There's D at the end of expire, which means that the person has run out of leave.
Okay.
And if you run out of leave, you cannot apply to switch to a new employer. So don't even attempt. You'll be refused. Or you don't have a visa to be able to switch.
Right.
However, you can consider applying under human rights, i.e., you have a child who is British or who is an EU national with 5 years, or a child who has indefinite leave to remain. Then you can apply to remain with the child because you are a parent in the life of this child. And therefore, under Section 55 of the Borders Act, it will be in the child's best interest for your application to be granted so that you can help with the child's care. Or you have a new lover, you've developed new relationship, you have remarried, and your wife or husband has a child, and therefore single mother or single father. So if your husband was a single father, or your wife was a single mother, then that stepchild will be the reason why you should be considered to live in the UK by being granted 2.5 years leave to remain, because the role you play in the life of this stepchild means that if you are asked to leave the UK, it may affect the life of this child in terms of the emotional, psychological, physical, and the financial support that you provide to your stepchild together with the entire family. And so under Gen 3.2 of the immigration rules, your application will be considered. And also under EX1, under the exceptions of the rules, that even though you don't have a visa, because of your new family ties with your stepchild and your wife or husband, you should be granted, and you'll be granted 2.5 years leave to remain.
We're still live with you on the Community on the Law, and it's brought to you by BWF Solicitors. My 10-year route is on the basis of my private and family life as a partner of a settled status holder. And I have a British child with her, but I have another child in Ghana, which I want to bring here. How would Ajanim go about it, lawyer?
I think Ajanim was the one I said that I don't know whether it's private or family. However, I responded on the basis that it is on the basis of a family. That means he was given 2.5 based on the first child, who is British.
Right.
And he wants to bring his own child from abroad, which that's the sibling of this British child.
Yeah.
He has to show some responsibility, or he has to show that not allowing the child to come will affect the life of the child under paragraph CHI 3.2 C of Appendix Children to the immigration rules. And because this is a family life application, the child's application will be under paragraph 297 of the immigration rules.
Okay. Well, if you need further information, as I said, you can contact BWF Solicitors 0208-493-7340. Or if you want to speak to lawyer Charles Asman directly, call him on 07947 63 60 37. 07947 63 60 37. Yes, and they'll help you. They'll definitely will help you. You know that. So yes, don't hide behind anything. I'm on a graduate visa that would expire in December 2026. If I get married to someone on the EU pre-settlement scheme visa, will my visa status change?
Right. So this someone, we don't know the person's nationality. Is this person British? Sorry, is this person an EU national or a foreign national? If you can assist. However, the bottom line is that the partner must be a qualifying partner. A qualifying partner is somebody who is an EU national resident in the UK, or a British citizen, or somebody with indefinite leave to remain. And even there are instances where you can even apply based on someone who is holding skilled worker visa. Either way, you'll be able to apply if the rules are met under paragraph RWP, that is relationship with a partner 6.2, to show that there is genuine relationship or partnership, and also showing that the relationship is ongoing, to show that you are living together and all these things are laid out. Then, before your visa expired, you'll be able to switch from graduate visa to family life visa. And I'm happy to tell you that somebody's visa was granted, I think last week. Similar situation. She met the boyfriend. They started their relationship. They even married in the UK by going through the process to get married through the council in the UK. And once everything was complete, we put in the application, and she's happy with her new 2.5 and the family life. So, my brother who asked the question, if you meet the rules, it is possible.
Okay, lawyer, could you report? Is that the same question? Yeah. Somebody sent me a letter, and for lack of time and for privacy, I won't mention the person's name, but based on the topic we discussed, there's a refusal letter. It says, dear Mr. XYZ, your human rights claim in an application for entry clearance made on the 22nd of June 2025 is refused. What it means for you, you can appeal this decision on how to appeal in the next steps. Then it gives us the reasons for the refusal. It says the decision takes into account as primary consideration your best interest as a child and those that
Paragraph 297 of the immigration rules states that the requirements to be met by a person seeking indefinite leave to enter the UK as a child of a parents or relative present and settled or being admitted for settlement in the UK, that he is seeking leave to enter to accompany or join a parents or a relative in one of the following circumstances. Both parents are present and settled in the UK, as you mentioned. Both parents are being admitted on the same occasion for settlement, or one parent is present and settled in the UK, and the other is being admitted on the same occasion for settlement, or one parent is present and settled in the UK, or being admitted on the same occasion for settlement, and the other parent is dead, or one parent is present and settled in the UK, or being admitted on the same occasion for settlement and has sole or has had sole responsibility for the child, or again, one parent or a relative is present and settled in the UK or being admitted on the same blah blah blah. They are saying relatively that this person doesn't meet any of these requirements, and the person is saying, "Can lawyer help me?" Yes, based on this and that, and from the discussion, probably you might have a case. Lawyer, would this person have a case?
There are, obviously, I haven't read, but there are bits that I didn't get. One, is this for a child?
Yes, for a child.
For a child. Is this her own or his own child? I suppose this is the biological parent. Was there a case of sole responsibility? We don't know.
Okay.
If there's sole responsibility, which he couldn't meet or the child couldn't meet, can the child now meet the serious and compelling family circumstances, which is under paragraph 297IF of the same rule that is quoted to make the assessment? If that is the case, we'll go to court. Then when we go to court, we rely on section 85 of the 2002 rule and the Asylum Act, and also Rule 14.2b of the First Tribunal Procedure Rules of 2014 to say that the child has serious and compelling family circumstances. Even though that was not available at the time of application, this is the evidence. Child welfare assessment report from the country, a lot of letters, everything that this parent has been doing, and the fact that there's nobody to attend to this child in terms of physical support and care. If that is the case, then we appeal to the judge to make a favorable assessment and determination that the child should be allowed to join the parent in the UK. If you are going to make a new application because you don't want to go through the long appeal process, then you can apply again, but make sure the evidence you are going to provide will be different from the one you provided, which was refused.
So yes, I will continue to advise that you give your work as a layperson for an artisan to do for you. And BWF solicitors are the specialists in this matter. So contact BWF solicitors. My friend that brought this letter to me, contact BWF solicitors, or you can even speak to Charles Osman, as I mentioned earlier on, and he will help you go through this. 0208-493-7340 is the number for BWF solicitors, and for emergency situation 077-127-61884. If you're in Ghana, 059-589-5959. Now with this, we go to, I give you the nugget and give you the scenario of my dear lady friend, and let's see what advice we can give to this lady friend. Selena applied for a visa to join her husband in the UK. This husband has indefinite leave to remain in the UK. Selena's application was refused because the caseworker was not satisfied that the payslips provided by her husband to meet the financial requirements were genuine. She's appealing against the refusal. She wants to include in evidence her husband's employment contract, a P60, and a letter from her employer to show that the payslips were issued by her husband's employer. However, she's not sure if the court will accept these new pieces of evidence since they were not part of the original application supporting documents. So let's advise Selena. The Home Office will challenge these new evidence because she did not submit them originally during her visa application. Another advice could be the court will reject the new evidence because the caseworker did not have the opportunity to consider them before the refusal action or decision, And then the third one, the court will accept the new evidence because they are relevant to proving whether Selena met the financial requirements or not. This was based on the nugget we brought you earlier on, and that was that the Immigration and Asylum Tribunal may consider any relevant evidence to the substance of the refusal decision, including matter or evidence arising after the decision was made. However, the tribunal cannot consider new matters without the Secretary of State's consent. A new matter is defined as a ground of appeal that has not previously been considered by the Secretary of State in the context of the original refusal decision. This is from Section 85 of the Nationality, Immigration and Asylum Act of 2002. Rule 14.2b, First Year Tribunal Procedure Rules 2014. Think about this. Laura is quite ready and apt to provide us help to get the right answer after this. Welcome back and thank you very much. Let me acknowledge those of you on the platform: Sandra Fiza, Tilly Duma, Derek Wusu, and all the other ones that are on there. I appreciate your presence and your contribution. Those of you who have called, those of you who have sent in text and all the rest of it, thank you so very much. So let's help our sister Selena. Let's advise her. Is her appeal going to succeed? Are we saying that the Home Office will challenge these new evidences because Selena did not submit them originally during her visa application? Are we saying that Selena, the court will reject the new evidence because the caseworker did not have the opportunity to consider them before the refusal decision? Are we saying to Selena again that the court will accept the new evidence because they are relevant to proving whether Selena met the financial requirements or not? Send them text 0739920848 or to the comment section down below. John Boache has come through with number one. The Home Office will challenge these new evidence because Selena did not submit them originally during her application. Johnny, thank you very much. Who else has anyone for us? Solomon Paul thinks that the court will accept the new evidence because they are relevant to proving whether Selena met financial requirements or not. That's number three. Let's go on to the next one brought in by Obed Ajenim, and Obed thinks is number one. The Home Office will challenge the new evidence because Selena did not submit them originally during her application. Next, we have Gifty Mensah. Number two, the court will reject the new evidence because the caseworker did not have the opportunity to consider them before the refusal decision. Thank you, Gifty. Next, Lydia Barr thinks is number three. Thank you, Lydia. Let's go to the next one, which is from Sika in Team. Sika in Team thinks is number one. Thank you, Sika. Next, we have Emilia Mensah, number two. Thank you, Emilia. Next, Ajua Mpofu, number two. Thank you, Ajua. We'll go to the next one. Elizabeth Enyimedu, number two. So we've got
a few number twos, a couple of number ones, a couple of number threes. Well, set comes up to add to number three. The court will accept the new evidence because they are relevant to proving whether Selena met the financial requirements or not. Prince Niam, I guess that's what it says. Number one, the Home Office will challenge these new evidences because Selena did not submit them originally during her application. Ajani, you've gotten your question again. I would ask you, please speak to Lawyer Asma after the program. I'll give you his number, or you can call into the studio number as well, or you can call him on 0794760. Let me put that on the screen for you so that you can copy it quickly. 07947636037. Now, our dear friend needs advice.
Yeah.
What can we tell her?
So,
well, Tilly has just come in to drop number three. Thank you, Tilly.
all right. I'm happy to say that it's a live case.
Okay.
It's an appeal I'm currently dealing with.
Oh, okay.
So, yeah, it's an appeal.
So you're the right person to tell us what advice
It's an appeal I'm dealing with. So we submitted application. The sponsor had two jobs, so provided two banks, two pay slips, set of pay slips. One was 20,000, 23,000. The other one was 6,000, making 29,000. Then the decision is that they will not grant the mother, which is the spouse, and the stepchild, because the pay slip for the 6,000 salary job, they could not verify that it's a genuine employment.
Okay.
And on that basis, he couldn't meet the financial requirements, so they refused. They didn't say fake, but they said we couldn't. So what it means is that the issue is whether the financial requirement is met or not. And by providing a pay slip, which they are saying it is not genuine, then my advice to the client is that we have to go appealing, but to verify that it is, get the employer to confirm. So the contract itself, going to the root of this employment, the salary. Also, P60 to show that you've been working, and this is your latest P60. And even HMRC record to show that you've been paying your tax, and a letter from the employer to confirm that yes, you are an employee, and to then that will be part of the evidence to conclude or say that financial requirement is met, because this 6,000 from this job is still valid, and we apply under section 85 to say that the court should accept this. And because this is not about new matter, it's the same matter of financial requirement, so we don't need consent or permission from the Home Office, and the court will accept under section 85. Answer is 3.
So the answer is the court will accept the new evidence because they are relevant to proving whether Selena met the financial requirements or not. And with that, we draw the curtains down. Well, they are based on Section 85, Nationality, Immigration, Asylum Act of 2002. Rule 14.2, remember, from the First Year Tribunal Procedure Rules 2014. We come to the point where we draw the curtains down on the program and we want to have a summary of what we have discussed. And I'll hand you over to Lawyer Charles Asma.
So viewers and listeners, has your child ever been refused? Is the Home Office tormenting your child from joining you? The answer is, if that is the case, please don't lose hope. Don't be despaired. Your child can still apply to join you, whether under skilled worker, under somebody with indefinite, or under somebody with 2.5, or under somebody with British citizenship, or with somebody, of course, under EU, you don't really have to prove anything. You just have to show that this is my child. So we are looking at non-EU route. And on that basis, we say that there's still hope for your child. All you have to show is if there's no sole responsibility, then there's another leg still available to stand on for your child. Please get in touch and we will be able to support you so that you and your child will smile at long last.
Definitely, the smile is very important. I want it to be as broad as it's supposed to be. It's been a very wonderful experience this afternoon, having Lawyer Charles Asma with us explaining what we can do and how we can do that
when your child has been refused an entry visa to the UK. Visit BWF Solicitors on the website www.bwfsolicitors.com, or you can contact them on their social media handles, and you will get a lot of information. You get the ability to contact them and also the ability to learn a lot. And they give us the opportunity to come your way every Saturday afternoon on BWTV with the program The Community and the Law. Leasma, thank you very much. BWF Solicitors, thank you very much. And to our numerous viewers and our clients out there, thank you for your time this afternoon. We spent 2 solid hours with you, and it's been a really good experience. If you are new to the platform, please go to the comment section down below, click on the notification button, and click on the like button, of course, and subscribe to everything that we put on so that you not lose out on our live programs. And if you missed a live program, you can go back to our platform at BWF Solicitors, both on Facebook and YouTube, at BWTV UK, both on Facebook and YouTube, and you'll get a lot of information. All our videos are there, and they will be there for as long as Meta and Google would want to keep them there. Well, we have another edition for you same time next week. So I'm extending an invitation to you to come join us same time next week on the same platform where we bring you another good edition of The Community and the Law. On behalf of my producer, Professor Ade, admin, and coordinator Sheila Ankara and Pat Mododu for the aesthetics. But before then, Leasma, we want to say thank you again. Thank you, and thank you so much. My name is Ulrich Frimpong. Have a good evening.